Good evening, Doctor. My name is Kimberly, and now I'll be presenting about the Latin maxim Cuius est solum eos est asqua et coelum et inferos, which is also known as to whomsoever it belongs, it is his all the way to the heavens and all the way to hell. It is originated from a Roman private law, meaning that property or territory extends upward into the atmosphere and downward to the earth's core. It addresses the question of how far a landowner's rights over a piece of immovable property extend, including both the airspace above and the subterranean space beneath. So historically, this maxim formed the foundation of English property law, granting property holders rights to not only to the plot of land itself, but also the air above and to the ground below. However, in contemporary law, this principle is only accepted in a limited form, and the rights are divided into airspace rights and subterranean rights. So for example, airspace rights are only restricted to the height necessary for the ordinary use and enjoyment of land, but does not have the rights to control flights far above the ground, whereas subterranean rights are curtailed by statutory regimes and technological realities, including Petroleum Act, Coal Industry Act, Infrastructure Act, and more. So the maxim enables property holders to manage, lease, or defend their land, but these rights are no longer absolute. Modern frameworks have now balanced private property with public interest, industrial development, and technological progress. In light of the history of this maxim, it dates back to the 13th century Italian juris Accursius and became a foundational principle of common law and was popularized in England by William Blackstone in the 18th century. Traditionally, it implied absolute vertical ownership, giving landowners control from the core of the earth to the heavens. However, Blackstone emphasized that land included everything in a vertical line above and below the surface. This is because in early English common law, disputes over airspace or subterranean space were rare due to technological limitations. However, with the rising of aviation, satellites, and mineral extractions, it has rendered that absolute vertical ownership is actually impractical. Modern law has now limited rights to what is necessary for the reasonable use and enjoyment, reflecting a functional and flexible approach that balances landowners' rights with public interest. Therefore, it is also said that historically the maxim served as a conceptual anchor for three-dimensional property, but critically this has failed under technological advances as time passes, showing that legal doctrines must also evolve to remain relevant in times like this. Now, in regards of ad coelum, meaning the law in discussing immediate of the ownership of airspace, historically the maxim suggested that a landowner has the rights definitely in the vertical dimension, from the center of the earth to the heavens. This meant that a landowner could theoretically prevent any intrusion into their airspace, no matter the height. In Carlson and Imperial Tobacco Company 1957, this case has confirmed that even minor intrusion into the airspace above someone's property can also be considered as trespass. So this decision has also set a precedent indicating that any unauthorized overhanging structures or objects, regardless of size, could lead to legal action for trespass. However, modern developments have limited this. In the case of Bernstein of Ley and Skyviews and General 1978, this case has taken a different approach, which is the reasonable height test. As said by Griffiths J., if the maxim was applied literally, it would actually lead to absurdity of trespass being committed every time a satellite passes over someone's property. So therefore, the court ruled that landowners only has rights in their airspace to such a height as is necessary for ordinary use and enjoyment of the land. So flights at reasonable altitude are not considered trespass, but low-flying drones, cranes, or overhanging trees may interfere with practical land use. And similarly, in the case from the other jurisdiction, which is Cosby and United States 1946, the court has also rejected indefinite upward ownership, holding that landowners retain the immediate airspace control to protect their enjoyment of the land, but not the upper airspace, which is actually considered public. The court also noted that ad coelum had no meaning in the modern world. This illustrates that the original ad coelum maxim is incompatible with modern aviation and public interest consideration. Besides, in the case of Anchor Brewhouse Developments and Berkeley House 1987, it has further clarified the distinction where tangible structures oversailing land such as crane booms constitutes trespass, even if they extend above the height necessary for ordinary use. It is also noted that the approach in Bernstein was actually distinguished by the High Court in Anchor. According to Scott J., it was stated that Bernstein only applies to objects flying above the land and not to structures and objects built on neighboring land which overhang the claimant's land. In those cases, the claimant has full and unlimited rights to their airspace even beyond what is necessary for ordinary use and enjoyment of his land. It could be concluded from here that the maxim's literal application is actually considered obsolete. In modern airspace law, they adopt a more functional approach, balancing private rights with societal needs. So courts have also distinguished between public airspace and trespass, reflecting a more policy-driven limitation of historical doctrine. This has demonstrated that while ad column informs conceptual understanding, it must be applied pragmatically, ensuring that landowners' rights do not obstruct with the public use. So now moving on to ad inferos, which talks about the ownership of subterranean space. Historically, the subterranean space mirrors the airspace ownership, where landowners can control anything beneath their land. According to Blackstone, it was stated that land hath also, in its legal signification, an indefinite extent, upwards as well as downwards. Whatever is in a direct line between the surface of the land and the center of the earth belongs to the owner of the surface. Though following at a slower pace in modern land law, but there has also been actually a rethinking of the ownership of underground space. So as the human understanding of Earth's core grew, it became apparent that the Cuios et Solem maxim was scientifically untenable. At the same time, in many jurisdictions such as Australia, England, the US, technological developments which enabled the increasing exploitation of minerals, gases, and other resources found under the surface of the earth provoked debates about the limits of the surface landowner to rights over the underground. So such as in the landmark case of Bocado SA and Star Energy UK Onshore Limited 2010, it had clarified the modern approach. So Bocado is the first modern case to consider how far beneath the surface a landowner's title to land extends, and whether the landowner can sue for trespass for underground incursions into the subsoil and substrata. In this case, Star Energy drilled wells diagonally beneath Bocado's land at 800 to 2,900 feet depth. The Supreme Court held that prima facie the landowner owns everything below the surface, is deemed to be in possession of it, and can sue for damages for subterranean trespasses. Judge Hope, delivering the lead opinion, reaffirmed that English common law regards freehold title as extending downward indefinitely unless expressly severed. The depth of 800 to 2,900 feet does not reach a point of absurdity. Therefore, the wells occupy land owned by the plaintiff. However, Section 10 sub 3 of the Petroleum Production Act 1934 denies petroleum licensees any right to enter on or interfere with land, absent separate authority. The court found no express or implied license and noted that an underground way lift is an ancillary right, obtainable only through the Mines Working Facilities and Support Act 1966, which had never been invoked. Consequently, the defendant had no statutory immunity to this case. Moreover, the extent of subterranean ownership today is not solely determined by common law only, but it is also heavily influenced by statutory frameworks. Some significant examples are such as, firstly, the Petroleum Act 1998. The purpose of this act is to consolidate and simplify UK law regarding offshore petroleum activities, including licensing, operations, and the decommissioning of installations and pipelines. So in Section 2 sub 1, the vested ownership of all petroleum in the Crown, effectively stripping private landowners of rights to subterranean oil and gas. So this represents a clear rejection of the Cuios et Solem maxim's literal reach. The Act is set to reflect Parliament's view that valuable underground resources should actually be managed for national benefit rather than private exploitation. And other than that, the other statutory frameworks are such like the Coal Industry Act 1994, which restructured the coal industry in the UK, initiating the privatisation of the British Coal Corporation. The Act aimed to increase efficiency and market competition within the industry. Additionally, it established the Coal Authority, which will assume regulatory functions, manage coal reserves, and ensure mine safety. Once again, the statute displaces private ownership in favour of national regulation, demonstrating the deepening control over subterranean resources. Additionally, the Infrastructure Act 2015 introduced in response to the growth of the renewable energy sector, developers of shale oil and gas and geothermal energy projects, carbon offset providers, and UK house builders. This is because until now, the law of trespass required those seeking underground access for shale gas or similar exploration and production activities to either obtain consent from landowners or go through lengthy application to court. Therefore, Section 43 of the Infrastructure Act 2015 provides a new statutory right to use deep-level land for the purpose of exploiting petroleum or deep geothermal energy in UK. So this gave rise to the real threat of anti-fracking landowners affecting the development of the shale industry in UK by refusing consent to access. Hence, this Act reflects Parliament's recognition that absolute ownership to the depth of the earth is incompatible with modern technological and economic demands. Lastly, the Mines Working Facilities and Support Act 1966 was passed in the UK to streamline the process of mineral extraction by addressing legal obstacles and providing a mechanism for companies to obtain the necessary permissions to work minerals. This statutory mechanism reinforces the idea that exclusive subterranean ownership is not absolute but subject to public and industrial necessity. This act embodies a pragmatic compromise between private ownership and national resource exploitation, reflecting the modern functional view of land as a platform for competing interests, rather than a closed private domain. Collectively, these statutes show that subterranean rights in modern English land law are shaped as much by regulation as by ownership. Although Bocado's case confirmed that underground trespass still exists, Parliament has since restricted the landowner's exclusive control, especially for national energy and infrastructure projects. Taken together, the modern law governing airspace and subterranean space illustrates that the maxim "Cuius est solum" no longer accurately defines the extent of landowners' rights. Courts have consistently adopted a functional and contextual approach, assessing ownership according to the reasonable use and enjoyment of the land. For airspace, the distinction between lower and upper airspace ensures that landowners' rights are protected only where practical interference occurs, balancing property interests with public accessibility and technological development. And for subterranean space, Bocado confirms residual rights but demonstrates that statutory schemes, public resource interests, and minimal interference often limit the enforceability of absolute claims. Statutory interventions also play a crucial role in moderating the maxim. So like the Petroleum Act, Infrastructure Act, Coal Industrial Act, and Mines Working Facilities and Support Act collectively illustrate that public interest and industrial utility frequently override common law property rights. Judicial trends further emphasize practical impact over literal interpretation, reflecting a broader principle in modern English law, which is property rights are not infinite but are defined by function and utility. So in conclusion, the maxim "Cuius est solum" historically defined absolute vertical property rights, but modern law imposes practical, statutory, and public interest limitations. Airspace rights are confined to the strata necessary for ordinary use, while subsurface rights are moderated by statutory regimes, technological feasibility, and industrial needs. The maxim remains a conceptual anchor, emphasizing the three-dimensional nature of property. However, literal application is impractical in modern contexts. Cases like Bocado show continued recognition of subsurface ownership, while statutes demonstrates the legal evolution towards balancing private rights and public necessity. Overall, "Cuius est solum" illustrates a transition from absolutist doctrine to a pragmatic functional property law, reflecting broader societal and technological shifts. It also provides historical context, conceptual guidance, and a framework for resolving modern disputes even as its literal force has been curtailed. Thank you.